what kind of presentation you would prefer for today. She told me migration in general, but so far I've seen that your focus, your concern is mostly on asylum issues. So the slides that you see here cover the full range of issues. Migration, it might be useful as well to make a slight distinction in this regard from the perspective of the court between asylum issues and migration issues, because the test used in Strasbourg in relation to asylum cases is different from the test used in relation to migration cases. And we'll go through very quickly. But as I said, I'll focus mostly in the asylum issues. And this is just a kind of introduction. Who is an irregular migrant? Who and how? So the person, put it in general terms, who find themselves not in a regular position in the country where they live. So asylum seekers is one of the categories of what we might call illegal or irregular migrants. The first issue, there are no dedicated articles of the European Convention of Human Rights to the asylum seekers or migrants. However, as most of the writers dealing today with the asylum issues say, European Convention of Human Rights has turned itself probably in the most effective instrument for the protection of the asylum seekers in Europe. Although EU law, as you know, is much more detailed, the legislative aspects. And in this regard, of course, I have to praise the work of the European Court of Justice, or Court of Justice of the European Union in Luxembourg. Still, the Strasbourg Court remains, and we'll see in a moment how and why, remains a leading institution in this regard. We have in the Convention only 3 articles which kind of indirectly refer to asylum or migration issues, and 2 of them, they are mostly kind of more directly linked to the non-refoulement principles and the procedural safeguards in these cases. It is important to remember that the initial premise in Strasbourg in relation to asylum and migration rights was that the way of accepting timing remains a question of national sovereignty. And you see one of the first cases, Abdulaziz Cabales el-Balkandali. And the member states can regulate the entry, the length of stay, and also the expulsion of aliens. However, following these cases, there have been a development in the case law of the court. I've mentioned here Sijama, that probably most of you know, which is the leading case on the non-refoulement principle. I might mention as well that next Wednesday there is going to be a Grand Chamber hearing in the case of Khalifa versus Italy, which is more or less in the same kind of issue. There's been a judgment of the second section of the court last year in that case, and it will deal with the question of non-refoulement. So in here, Sijama, the court said again that the control of the entry, residence, and expulsion of aliens is, in accordance with international law, a matter of member states. However, we move from this initial premise, and we see these are legal instruments used by the court, kind of especially with the aim of the effective protection of convention rights, for example, right to life, procedural rights, right to be protected against torture, ill treatment, all these have brought to development of the case law, family life as well. I mentioned Abdulaziz in 1985, the starting point. Then we have Söring, which does not deal with, is an extradition case. However, the principle was established there in 1989 that a person being removed to a third state, in that case was the United States, if he or she is being subjected to violations of Article 3, then the responsibility of removing state might arise under the convention. And then this principle was extended to asylum cases, and this is the case Cruz-Varas versus Sweden. In the Barajah, very quickly, within a year, the principle was confirmed. It is interesting, especially for the times we are living, in Shahal versus United Kingdom, the principle was consolidated. Why? In that case, the United Kingdom government, referring also to Hugo Grotius, said that person Shahal was a terrorist. Said that persons who have been authors of atrocities towards other individuals do not attract the protection of Article 3 in these cases, so they should not have, they should not benefit of asylum protection. However, the court said, no, this is an absolute right, Article 3. You might find the difference with the analysis under Article 8, for instance, and we'll talk briefly later. So in Hirsijama, after paragraph 113 that I mentioned earlier, the basic premise, you find paragraph 114, and in most of the asylum cases of the court, you'll read these kind of tandem, basic premise, and then the following paragraph, which says, however, expulsion, extradition, or any other measure to remove an alien may give rise to an issue under Article 3 of the Convention, and hence engage the responsibility of the expelling state under the Convention, where you have in red all the critical elements under the analysis of the courts in each case, where substantial grounds have been shown for believing that the person in question, if expelled, would face a real risk. It's a question of risk. For example, in MSS, Tarakel, in other cases, we've been dealing with general risk or individual risk. To treatment contrary to Article 3 in the receiving state, the threshold, Article 3. So in this paragraph, you find all the elements of the court's analysis in asylum cases. And 115 as well is very important, because in asylum cases, differently from all other kinds of cases in Strasbourg, the Strasbourg court is required to act as a first instance court, basically, because we proceed with an ex nunc analysis. You can also see in this regard the latest judgment of the Grand Chamber, FG versus Sweden, where there is a kind of specific focus on the ex nunc analysis, and there is another judgment by the Grand Chamber which should come out probably before summer, JK versus Sweden, again mostly dealing with the methodological issues. So the question is, which convention article? These are mostly the convention articles entering into play, which I repeat, at the beginning, none of those was conceived to play any role for the asylum seekers. Now you have a full body of case law related to these articles protecting the asylum seekers and migrants. So I'm not going through one by one, so you have the main articles. There are two categories of cases, and I would invite you to be careful in the distinguishing the two, because, as I said, the logic of or the approach of the court changes in specific cases concerning with asylum seekers and then with migrants. Asylum seekers' cases concern mostly Articles 2, 3, 5, 13, Protocol 4, Article 4, so non-refoulement, procedural guarantees, etc. Migrants' issues, if we put it kind of as a specific situation, I'll mention it later, concern mostly Article 8, family or private life in very few cases, and Article 14, which is discrimination. And under migrants, also the type of analysis might differ depending whether we have migrants already established in the country or migrants wanting or seeking to enter in a specific country. So in this framework, you can make the difference as well. Some of the difficulties and methodological issues we face. Probably Karen has heard me saying this many times. I can tell you for the past 8 years in Strasbourg, the most difficult cases I had to deal with are asylum cases and children cases, by large, because there are a series of difficulties. Also, I believe Boston Jaller has heard me saying this in other conferences. Articles involved, so rights involved. Sometimes you decide life or death, because you remove somebody to a country where there might be a risk for his life or her life. A problem that you find there. What sources of information? In most of the cases, the Strasbourg judges are so far away, as national judges, by the way, from the country of destination that it's very, very difficult to decide. Last week, I was receiving a message from a British judge telling me, do you have any information on Eritrea, because I have to decide a case on Eritrean situation. And I asked the lawyers of dealing with asylum cases, what's going on in Eritrea, because it might be useful for our British colleague. It's very difficult. And especially I feel this now because I'm dealing with Rule 39 cases, which are the interim cases. Especially I'm covering Section 1 and Section 2, by the way, Greek cases, UK cases, Finnish cases, Turkish cases. And decisions related to Rule 39, I have to take them sometimes within half a day, because the person is just being removed, is at the airport. And these are very difficult issues. I would underline, analysis at national level. For us is extremely useful if the analysis at national level is professional, detailed, and respects convention standards. In the latest Grand Chamber case dealing with asylum, FG, I submitted a separate opinion just focusing on that case, on that issue. The analysis at national level has to be convention compliant. It's extremely important for us, because the national judges, they see the applicant, they assess at first hand the risks, so it's extremely important. Additional sources concerning political, health, economic situation, etc. So it was the question put earlier by you, Flip, about the role of the European Commission. I can tell you, for example, MSS changed the case law of the court based on the additional sources we had. We had ECtHR, we had the Human Rights Commissioner of the Council of Europe, we had all the NGOs informing what the situation in Greece was. So we changed the case law from KRS versus UK into MSS versus Greece and Belgium. But without these sources, for us, would be very difficult to change. I can tell you 2 weeks ago, as a single judge, I decided not to apply Rule 39 on the removal to Turkey. So the Turkish, you know that, the Turkish agreements. After, I can also tell you this, after a lot of hesitation and consulting several of my colleagues. I was also hesitating whether I should send this decision to the chamber, which I can. At the end, the sources of information I had, after consulting also the committees, the Greek committees' decisions that Turkey is not a safe country, on balance, I said, let's wait for a moment, let's see whether there are kind of other problems being brought before the court. And also I have to tell you that to reach that conclusion, I also asked the Turkish division whether we have cases against Turkey, because differently from EU, you have to see, of course, you know that Turkey is part of the convention, it's not part of the EU, but for us is the same as Greece or Germany or France or Belgium. So there is a different approach in Strasbourg compared with the EU. Diplomatic assurances, this is a specific issue, so I'll not focus on that. I mentioned the analysis ex nunc, and the court does conduct an analysis ex nunc, so at the situation of the country of destination at the moment when the Strasbourg court is taking the decision. And in FG, we said also we have to take into account also the changes into the personal situation of the asylum seeker. FG was converted from Muslim to Catholic in Sweden. The question of individual risk versus generalized risk. See especially Soufi and Elmi and MSS and Tarakel, which resolved kind of the dispute, entre guillemets, between Luxembourg and Strasbourg. As to the type of the analysis, it is important to mention the distinction between strict scrutiny. In asylum cases, we always conduct a strict scrutiny because there are in place Articles 2, 3, absolute rights of the convention. So we have to be strict there. Whereas in the migrants issues, we have a balancing exercise, which means that if the family life can be conducted in the country of the origin, we might, on balance, say they can be removed there. Whereas for asylum seekers risking lives, we cannot say in balance that person can be removed there. And asylum seeker as vulnerable person, especially Tarakel MSS, paragraph 251, and Tarakel as well. The last point is a kind of internal debate within the court, what kind of approach shall we adopt, individual complaints approach or constitutional approach. You might find interesting to read SJ versus Belgium. These are all the legal issues I could mention, but as I said, I'll focus especially on the first one for question of time, of course. The first issue, principle of non-refoulement, as you all know, is provided by the Geneva Convention. The court has insisted on this principle, which was also mentioned this morning as a kind of individual assessment in the case of each asylum seeker, because from the perspective of the court, it has a fundamental impact, lack of any individual assessment. And all the protection of all articles of the convention are removed if you do not have an individual assessment. You do not know whether the situation of the asylum seeker concerns Article 2 or 3 or 8 or whatever. This is extremely important. This has been confirmed in Hirsi Jama. We'll see, as I said, next Wednesday, Khalifa versus Italy. For example, these are the articles affected by a violation of the principle of non-refoulement. In all these cases has been decided violation, except Javara and others versus Albania and Italy, which is a situation more or less like Hirsi Jama, which was thrown out because of procedural issues. In all the other cases, was found a violation where the non-refoulement principle was not respected. Then we go into the Dublin system, so I do not need to make an introduction in this regard. You know, from the perspective of the court, and in relation to some of the questions which were asked this morning, for example, third safe countries, from the perspective of the court, I can say that all these formal definitions at the end might be irrelevant from our perspective. For us, the standard is effective protection, whatever name you give to the country, safe, third country, country of origin, whatever. And it is very important, because the principles were established in an inadmissibility decision in TI versus UK, were repeated as well in KRS and MSS, and you have the 3 points. This case, which is a decision of 2000, did concern the Dublin Convention at the time, before the Dublin regulation was enacted in 2003. First point, removal to an intermediary contracting state of any convention. Imagine whatever it is. Imagine also the agreement between EU and Turkey. That's why this is important. Does not affect the responsibility of the sending state. It would be curious to read EU, and you have to ask because EU is not a member of the convention. But what would be the impact of this conclusion for the Luxembourg court? Probably you'd have the chance to ask the Luxembourg judges. To ensure that the applicant is not exposed to treatment contrary to Article 3. The second point, the second state cannot rely automatically on the arrangement made in the Dublin Convention or regulation, mutatis mutandis, Turkey-EU agreement, or whatever agreement, readmission agreement. Third point, where states have established international organizations, this broadens up the principle, or agreements to pursue cooperation, there could be implications for fundamental rights. So be careful when you conclude these kinds of agreements. So TI was concerning Dublin Convention, KRS versus UK removal to Greece in 2008 concerned Dublin II regulation, and the court decided in July 2008 that there is a presumption of compliance with Greece because we are not sure that Greek problems were so high that would kind of serve to rebuttal this presumption of compliance. And then in MSS versus Belgium and Greece, within a year and a half, we reached a completely different conclusion. We said the presumption is rebuttable, and removing asylum seekers to Greece is problematic under the convention. The European Court of Justice replied to this principle, to this finding, in the case of NS, saying that asylum seekers should not be removed to countries where there are systemic deficiencies. They use this term as the distinguishing standard. And there was a kind of explosion in the doctrine, probably the standard was changed, and there are debates between Luxembourg and Strasbourg in this regard. And it is curious to see that also, especially one section of the court in Strasbourg started to apply this standard. You can see especially Dutch and Austrian cases. Mohamed Hussein versus Netherlands and Italy, Ahmed versus Austria, Halimi versus Austria, and etc., where the Strasbourg court as well started to use the notion of systemic deficiencies. The doctrine also asked, what does it mean, systemic deficiencies? They started to ask, what does it mean, systemic, systematic, where there is a definition in this regard. So we needed a good case, to find a good case to reply to all these debates that have been going on for a couple of years in Europe, if you follow the debates. And then we found out that Tarakel versus Switzerland might have been the good case for that. The case was sent directly from the second section to the Grand Chamber for reply to these issues, and the court confirmed the traditional standard, not the standard of systemic deficiencies, but the notion of risk. The standard we've used since Söring, since Abdulaziz, forever, taking into account the individual circumstances of the applicants and the general situation in the destination state. In that case was found a conditional violation, and this was a kind of methodological approach by the court, saying to the Swiss authorities, was done also with the aim of helping the operation of the Dublin system. Have guarantees by the Italians first, that upon removal, the family, there was a couple with 6 children in Tarakan, will be accommodated in appropriate premises for their conditions, and then you can remove them. So we didn't want to kind of throw away completely the system as such. So that's why we found a conditional violation. Also, it is important to mention that in Tarakel was underlined the fact that the applicant situation was a particularly vulnerable group. In AME versus Netherlands, the applicants were adults, so we decided that removing to Italy is not problematic. This is a case, Araniosi and Caldararo, which came out from the Luxembourg court, which came out either the 5th or the 6th of April this year, and is very interesting because it does not concern asylum. It does concern European arrest warrant, but the Luxembourg court says in this case that if there are doubts that removing a person from one member state to another member state, Hungary in that case, where the detention conditions might be in violation of EU Fundamental Rights Charter, then automaticity, for which the Luxembourg court has been criticized for years, of the application of European arrest warrant, for example, or Dublin System, should not prevail in these cases. So the person should not be removed. And this is, at least from my perspective, is a judgment which focuses into the individual assessment of each and specific case. There is no automaticity, an absolute automaticity in these cases. And I think this principle could be applied mutatis mutandis also in asylum cases. You've been discussing about the refugee crisis. I would invite you to read a paragraph of the concurring opinion of Judge Rosakis, my former colleague and still a good friend. He wrote this in 2010. We saw that the system was not up to the concrete situations. The Greek and Italy to a lesser extent, at the time Spain as well, Malta, clearer than this cannot be said. It was kind of smart to issue this warning. Oh, I have a problem here that I don't know how to. Okay, this is okay. Okay. So Judge Rosakis invited in 2010, was published in January 2011, a review of the system. We had only this May, should be down here. We have only this May 2 commissioners, the Vice President Timmermans and Avramopoulos. Timmermans said, well, the Dublin system is that like Jon Snow in the Game of Thrones. I haven't seen Game of Thrones, but this summer I have to see it to kind of figure out the metaphor. But for sure, I've seen how the Dublin system has been dying for years. But this was this was accepted by the European Commission in 2016, so it's 5 years delay. In 2012, there was another article by one of the judges of the court saying the title was, the title of the article in the Cypriot Review for Human Rights was "For Whom the Alarm Bells Are Ringing." And it was clear, and the Dublin system was collapsing. And still, the recast in 2013 tried to take into account some of the messages, but still not up to the questions, fundamental questions that were posed. Some of the issues, borders closing. I've been dealing also with an issue concerning the Idomeni camp, which was very difficult as well to decide. There are 6 children, unaccompanied minors, with health problems. And also I've kept this case for a couple of days what to do, because there is no kind of risk of removing. It was a question of the conditions in the Idomeni camps. And then we decided to ask the Greek government for information and to apply temporarily Rule 39. And at the end, the Greek authorities sent all the children, sent them to hospitals and to kind of appropriate premises for their situation. So this is a problem as well. But the case is still with the court. And the case is against Greece, Macedonia, Serbia, Croatia, I believe, Slovenia, and Austria. So the case is against all these countries in a row, if you see the roadmap. So the case has to be decided still on the merits. Non-registration of asylum seekers, it was mentioned also this morning. An agreement with Turkey you have been discussing as well. Do the European Union member states, Greece especially, remain responsible? This would be for sure, this would be a Grand Chamber case if it comes to Strasbourg, the issue of the Turkish EU agreement. I would skip this and bring you to the Abdulaziz criteria. And this is a migration case. It's not an asylum case. So please make this distinction. There you have a balancing exercise. There is no strict scrutiny in these cases where there are issues of family rights is Article 8 of the Convention at stake, family rights or private rights issues, and you see the principles established by the court in these cases, especially the one Article 8, it says, does not entail a general obligation for a state to respect immigrants' choice of the country of their residence and to authorize family reunion in its territory. Positive and negative obligations in this regard is very important to see what I could call the cheating situation, where is a situation which shows that where the migrants or the family aware of their precarious situation from the beginning. I mean, there are especially the contract marriages, all these situations. So this notion has been developed by the court in this regard. So you have in the Jeunesse case versus Netherlands in the Grand Chamber, all these elements, but the element which made the court kind of on balance decide for a violation was the best interest of the child. So in cases where removing a child to a country with which the child doesn't have any kind of relationship, is completely new, doesn't know the language, doesn't have family beside the close family, then the court said that in this case there might be a violation of Article 8. In all the other cases, the balancing exercise might conduct into the finding of a non-violation.